Mr. Novotny, you may proceed.
Thank you, Your Honors. My name is Doug Novotny. I'm the attorney for the appellant, Jason Bluml, and this has to do with a workers' compensation case. The main question in front of the court here today is whether or not an idiopathic fall onto a level floor surface is compensable when the hardness of the floor affects the severity of the injury. So in this case, Mr. Bluml was working at a Long John Silver's restaurant in Council Bluffs, Iowa. And on February 15, 2012, he fell back, straight backwards, struck his head, causing severe injuries to him. He incurred a traumatic brain injury, a very severe one, where he underwent neurosurgery, and he has many cognitive impairments, most of them dealing with language and memory and those type of issues. So it's been a very traumatic injury for him. He filed a workers' compensation.
What does the record show that the hardness of the floor increased the risk of injury?
Well, the floor was a tile ceramic floor, and even the commissioner stated there's no real dispute that injuries sustained by claimant were rendered more serious because claimant's fall occurred on a ceramic tile floor inside defendant's employer's restaurant. And also his physicians have indicated that the fall to the floor caused his injuries.
But this is a restaurant, and, you know, what are they supposed to have, carpet underneath the grease fryer? I mean, you know, a restaurant has certain equipment and certain materials, and if they're standard materials, how does that increase the risk?
Well, it's certainly a condition of his employment. A fast food restaurant would not have a carpet because of spillage and those type of issues. And so he worked there, and he has those risks when he goes to work that this could happen. In this event, he fell, and it caused severe injuries to his head and brain, as opined by his physicians. And so this is clearly a condition of his employment that we believe aggravated and made his injuries more severe.
The brain injury caused by a fracture, or was it a contractile injury? What kind of injury was it?
He had subdural hematomas to the brain, the frontal lobe injuries. They did neuropsychological exams that were all abnormal, showing that he had problems with language and memory and things of that nature. So he had a neurosurgeon that had to do craniectomy and also cranioplasty. They had to have a bolt to his skull, implanted onto his skull and then taken out. So we believe that the Iowa courts in the past have would rule in our favor as to our theory of that idiopathic fall should be compensable when the hardness of the floor makes the injury more severe. And the first case that we looked at was the Ladwig versus Farner-Bakken case, which was a workers' compensation action. In that case, a gentleman was working, he was standing on a pallet jack, and he had a hypoglycemic reaction. And so it was an idiopathic fall, similar to this type of case. Now in that case, the deputy commissioner felt that this was a compensable event for a number of reasons. Number one, that he was standing on a pallet jack, which was about 3 inches off the floor. Also that he had fell across the pallet jack, which was a machinery that he fell on. But third, it's stated in his opinion, goes, it has also been held that the hardness of the floor struck during the fall can constitute a sufficient element of risk or hazard as to make the fall arise out of employment. An idiopathic fall to a concrete floor may be compensable because of the effects of the hard surface. So they reference to a case in Mississippi, which was the Chapman Dependence of versus Hanson Scale Company, 495 South 2D 1357. In that case, a worker was working at a restaurant as well, I believe, and he He fell as a result of grand mal seizure, and it was held that his death was caused when he struck the concrete floor of the employer's premises. And in that case, the Mississippi Supreme Court held that this was a compensable event. They stated, "We regard the floor as an appurtenance of the employer's premises, the same as any other piece of equipment or fixture. We see no appreciable difference between a worker's collision with another piece of equipment, a table or a trash can, which could be compensable on the one hand, and a collision with a concrete floor on the other. Both are collisions by the worker with an appurtenance of the employment. Both are encounters by the worker with an employment risk. Both contribute to injury or death, and as a matter of law, both arise out of in the course of employment." So the Iowa Workers' Compensation Court specifically referenced to this Mississippi case.
And part of the problem with this is, I mean, if we interpret the relevant language, which is arising out of employment de novo, and recently in our workers' comp decisions, we've been interpreting the statutory language de novo, then really we don't defer to what the commissioner has done in the past or to what the Court of Appeals might say in unpublished opinions, some of which are cited by the other side. Let me ask you about, there's a case from your state that came out earlier this year involving a fall. Marilakis, are you familiar with that case in the
Yeah, I believe
Walmart?
so,
Yeah, and how do you distinguish that case? Because it seemed there that recovery was denied after the court concluded there was no evidence it was anything other than a direct fall to the ground in the Walmart.
Right, and I think, I just believe Iowa follows a different way of thinking about these cases. Specifically, Iowa has stated that it has abandoned any requirement that the employment subject, it says it has abandoned any requirement that the employment subject the employee to a risk or hazard that is greater than that faced by the general public. In most of these cases that the defendant cites to, they state that they deny compensability because the person is subject to the same type of conditions as someone in the general public. And so this is completely different than how Iowa looks at these type of cases, in my opinion, and from the case law, specifically the Whitaker AARP case. And in that case, there was a janitor. He was in the break room and he was eating something, and he started choking. And so he tried to stand up to get a drink of water. He tripped over. He was going towards the table. He kind of tripped over the table, and then he fell into the wall, and then hit the floor, hard floor. And I think we should go back to what the original decision was in the Iowa Workers' Compensation hearing. And basically what the judge had indicated in that, he once again kind of mentioned the Mississippi case. He said, "It has also been recognized that where a claimant falls and hits the floor, the hardness of the floor struck during the fall can constitute a sufficient element of risk or hazard as to make the fall arise out of the employment. An idiopathic fall to a concrete floor may be compensable because of the effects of the hard surface. Here is both the hardness of the wall upon which the claimant hit his head that primarily caused claimant's injury, and the hardness of the floor, which also contributed to his facial injuries, which constitute the element of an adverse work condition." So then he goes on to state that if he was in a different part of the building and he fell on concrete, this may not have happened. He wouldn't have such severe injuries. Specifically states, if the wall claimant fell against had been of some material other than hard concrete, the effects of his head hitting it would have been less onerous. If he had choked and passed out.
The Whitaker case that you're talking about, that was unpublished, right? It wasn't a decision of our court, correct?
The one I'm speaking of right now is the Iowa Workers' Compensation decision. Then it was a Iowa Court of Appeals.
Yeah,
Yes.
looking at our own decision in the Wills case, Kaler Electric, it was an idiopathic fall off a ladder, and it was held to be compensable. But the court noted the risk of injury is greater when one falls from a height of 4 to 5 feet onto a concrete floor than when one falls on a level ground. So we seem to draw a distinction between just falling on a level floor. So we don't have a case from our court yet. Maybe this will be the one. But what's if the purpose of work comp law is to protect the worker from the hazards of the working environment and to make the employer pay for those, I just have trouble with the idea that a tile floor qualifies.
Well, in the Whitaker case, it was a hard concrete wall that the individual fell into, and I suppose if anybody wanted to make a workers' compensation claim, they could look at that case and say, I'm going to fall into a hard wall. It also occurred in the Banco case, where a person also had a fainting episode and struck the back concrete wall behind a bathroom stall. And in those cases, they found that the work condition aggravated the injury. And that's exactly what happened in this case.
We have that toilet case where the guy just turns around to flush and hurts his back, and our court held that was not compensable.
Well, I don't think there's anything to show that being on the toilet caused his injury. In this case, though, him hitting his head on that floor was a direct cause of his injuries, and he's got very severe injuries, traumatic brain injuries that he still is dealing with today.
He was delivering an order, as I remember, when this happened, right? He was actually, when the witnesses saw like a bag of food on the ground next to him that he was probably bringing to a customer. Is that right?
Yes, he was working behind the counter of the fast food restaurant. I believe that's true. I'm not exactly sure if what his duty was at the time, but yeah, he was behind the counter at the time. Mm-hmm. And so when I look at all these different cases, it certainly seems to me that Iowa wants to try to do the best for the employee in these type of situations. And like I said, they've abandoned said in the Whitaker case, they said abandonment any requirement that the employer subject the employee to a risk or hazard that is greater than faced by the general public. And all it has to be, it doesn't have to be a dangerous condition. It just has to be placed in a position that aggravates the fall. So in this case, the hard floor surface definitely aggravated it and made his injuries more severe. And so I believe that I think the weight of the cases that have been decided in Iowa would go with this court following the jurisdictions that find that the hardness of a floor can affect the severity of an injury and should be compensable under Iowa law. There's also other examples in my brief of some other cases. And going back to your question, there's a Texas case that states that working on concrete is a instrumentality of the job. Same here. The hard tile surface was a condition of his job. A fast food restaurant is not going to have, like you said, the carpeting in the back area, so he's exposed to that risk. If he should overturn the decision, reverse the decision, we believe that Mr. Bluml should be entitled to permanent disability benefits. While he has gone back to work, it's basically due to the fact of having a really great employer.
Mr. Novotny, if we did reverse on the issue of whether the fall is compensable as arising out of employment, wouldn't it be up to the commissioner then to determine all those issues?
I suppose so, but I just want to, if the court here was going to go over all those issues, then I certainly want to put those in my brief as well. So I guess then the main issue here then is to focus on these cases. I think if you go back and you look at all these workers' compensation cases and the Iowa Court of Appeals All these cases indicate that.
Counsel, you're talking about all these cases. Opposing counsel's brief says the majority rule, and the Larson treatise would say a fall on a level floor is not compensable. Which position is better grounded in the law?
I guess my time's up. I guess I'll.
You may
Okay.
answer.
What's that?
You may answer.
Oh, okay. Well, I believe it's correct. The majority of jurisdictions do find that the falling on a hard level surface is not compensable. However, I believe that, as I stated, that Iowa law is quite different in these situations.
Mr. Novotny, thank you.
Thank you.
Ms. Dickson.
Good morning. My name is Jean Dickson, and I'm here with Paul Powers of my office on behalf of Long John Silver's and its insurance company, Commerce and Industry Insurance Company. This is not a medical causation issue. This is an issue of first impression on purely the issue of arising out of. This is not an issue of in the course of employment. This is an issue of arising out of.
But doesn't the medical issue have something to do with it? I mean, if he fell on the floor and had sort of like a contractile injury where there was no subdural hematoma or an ordinary concussion because your brain was pushed against the skull, I could see that. But here, this gentleman suffered a subdural hematoma, which indicates to me at least that the concrete floor caused his brain to bleed at the point of contact.
But I
and
think,
that
I'm sorry.
and it seems to me, does that increase the risk when you fall on the concrete floor taken in the metal? It's sort of, and I'm sorry I'm so long, but it sort of reminds me of those heart attack cases, you know, where just because you have a heart attack doesn't mean it's compensable, but if there is some stress or extra risk or something else from the employment, then it's compensable. And I think the medical may have something to do with this.
Well, we wouldn't be here if the claimant hadn't been injured. But any level surface hard enough to cause injury, we would be here. So if you did have a carpeted floor where he fell and he bruised his head, that the carpeted floor, you could easily make the argument that there should have been more carpet.
But when you fall, you may get a concussion. When you fall, you don't get a subdural hematoma.
Well, if you fell on a carpeted floor and got a concussion, the issue would still, we could still be here for that same, we could still be here. Obviously, we wouldn't have the severity of the injuries.
But that's not the facts of the case. Like, if you have a heart attack, it doesn't mean anything on the job, but if you have a very stressful job and something stressful situation, you get a heart attack, then we say it's compensable.
Right, and
So I
that's,
think you gotta look at the medical part of it to see what was the injury caused by the fall. And I agree with you. If you fall and get a concussion, I don't see where there's an extra risk. But this gentleman didn't get a concussion. He got a subdural hematoma, which you know means that it was hard enough for it to cause probably a vessel to break and to cause a bleed.
well, and then I think you would jump over to the court's instruction and Justice Snell's language in the Medema case and look at, I mean, Iowa has recognized that we're not an increased risk state, and I know some of the cases that we cited are increased risk. Illinois, for example, they're an increased risk where you look at your risk versus that of the general public, but you still have to have an actual risk associated with the employment.
Can't the hardness of the floor in some contexts be the kind of instrumentality in the place of employment that results in an injury arising out of employment? For example, let's take a situation where the claimant develops plantar fasciitis from walking on the hard floor repeatedly during the workday. In that situation, the hardness of the floor arguably is a sufficient workplace circumstance to bring the injury to one that arises out of the employment. Why should we view this one differently?
Well, in that situation, like a plantar fasciitis case, the actual risk associated with the employment wouldn't just be the hardness of the floor. You'd have a contributing factor, that being excessive walking, excessive standing. All the other cases that are cited always have some kind of extra, additional factor. So plantar fasciitis, I agree that would be a different case, and I know counsel cited a plantar fasciitis case in his brief, but there, and again, we're looking at the actual risk associated with the employment. Here, the record is clear, and I know counsel raised some issues with respect to this configuration of the room, but if you look at page 18 and page 21 of the appendix, that's the factual findings of the arbitration, of the deputy and then of the commissioner. The only factual finding was the hardness of the floor, and that's the issue, is the hardness of a floor the actual risk associated with employment?
But couldn't this be, Ms. Dickson, just a factual matter? I mean, I mean, you would agree probably under our precedent that if he had been standing on a stool and had the same fall, the very same idiopathic fall, then that would be compensable. So, I mean, what's wrong with leaving it up to the commissioner to decide as a factual matter? Is the hardness of the fall a risk factor associated with the employment that increased the risk? Rather than us deciding that as a matter of law.
Well, that's the issue that we're here. Like, once the idiopathic, when you start with an idiopathic fall, and the evidence is very clear, there's no dispute that that's an idiopathic fall, that's a personal risk case. We have a gentleman that went straight to the floor. That's gravity. I mean, anybody that falls that doesn't have an obstructing a factor is going to go down. And so the issue is really, if you go down and you don't hit any factors, any conditions associated with the employment, I mean, our position is once you hit that floor, once you hit that level ground, it's not compensable. It doesn't matter, you know, if it's just a level ground, if it's not covered with nails, if it's not covered with some hazard, that it's not compensable. If you look at Medema, and Lynn,
But why would hitting the wall be a hazard, a workplace hazard, but hitting the floor would not be? That doesn't make sense to me.
Well, because the wall is the configuration of the room. Well, the floor is gravity. I mean, that's our, I mean, if you fall down and there's not something in the way, you're going to go down because that's gravity. I mean, you're not going to go up, you're not going to go side, you're gonna
Gravity caused you to fall on the wall. I mean, if there was no gravity, you wouldn't fall.
True, but the wall's on the way down. In this court, in Kaler and Lakeside, McElravy, they've always recognized that if there's a hazard on the way down, that's it. I mean, I look at, like, I get these questions from I've been doing this kind of stuff for 25 years, and this is the question I get almost every week, is a question on arising out of. Hardly anything comes up. And so I always look at, and if we take a step back, I tell my clients, is it a risk associated with the employment? The Workers' Comp Act is designed to protect the injured worker, and I understand that, my client understands that. What do I tell my client? In almost any other situation, there's something you can point to that is in the condition of the employment that contributed to the fall. Here, all we have is we have him going down. Now, I know there's a medical evidence that establishes that he would have been, the medical evidence establishes that the injury was aggravated because it was a concrete floor as opposed to a rubber mat. But that's, in our position, that's a medical issue. That you wouldn't even get to that because our position is under Hansen and Medema that it's a personal risk. There's no actual risk associated with the employment that would make it compensable. I pulled out some words, and I mean, I know obviously when you're going through this and you'll be reviewing Medema, but if you look at Justice Snell's analysis in the Medema case, he talks about the injury being more than a coincidence, an exposed risk, a rational consequence, and a hazard. And how can a level floor be a rational consequence in an actual hazard? Justice Wiggins raised the issue about what if he fell and it was a concussion on a soft floor. I mean, under this, under what Mr. Bluml's asking this court to hold, I think that would be a compensable injury too. So the majority,
Might be, I guess my question is, why couldn't you go in and make the argument? Why should we, as a court of law, not as experts on employment conditions, be deciding as a matter of law that some things you don't even get to go in and make the argument to the commissioner on?
well, I mean, Larson's is instructive on that issue, and obviously this court has.
I agree, he agrees with you. I agree with that.
And looking at some of the cases, again, I think you more maybe just almost take a step back. But if you look at some of the cases that we cited, and again, these are instructive. There's nothing that's controlling, I think, really for this court other than Medema and Hansen, unless obviously you decide to. I mean, nothing's really controlling in terms of this issue because obviously you can do whatever you want with the Hansen and Medema too. I don't mean to tell the court what's controlling. But if you look at, for example, the Zakowski case, you could fall on a cement floor without injury, but you might fall on soft sand and break a wrist. To hold that a concrete floor is a risk of employment, this is the Camino case, it's a Massachusetts one, would really result in a holding that that any flooring of any materials is a hazard whenever there's a causal connection. So if we go back to, for example, like what was I supposed to tell my client to do in a case like this? Well, you need to have carpeting. So you have carpeting and Mr. Bluml falls and he has an injury, but it's not quite so severe. But if we would have had an extra inch of carpet padding, it wouldn't have been so severe. So then you have a work injury. Well, then maybe you have 1 inch of carpet padding, but it's kind of cheap. So does he get a causal connection argument that, well, the injury was worse because you had cheap carpet padding? Is that a risk associated with the employment? I don't think so. And there has to be, it's not just causal connection. If you look at the Hansen case, they talk about an actual risk. If you look at the definition, you look at Webster's, the definition of risk and the definition of hazard, there's got to be something. Like Webster's defines risk as something that creates a hazard. Webster's defines
I know this
hazard.
is a fast food place, but in industrial settings where they have concrete floors, they wear hard hats.
That's true.
To protect them from a fall on the concrete floor. I mean, so there's other things, an inch of padding or a half an inch of padding. I don't know what's available out there, but that's an argument that someone has to make, because I'm not an expert in that.
I mean, again, but our issue would, or our position would be as to an actual risk of employment. And it doesn't have to be an increased risk, but there has to be some nexus. And our position is based on, if you look at the majority case law, and again, if you look at Larson's, but again, I think really what's most instructive for this case is Kaler, Hansen, and Medema.
But Larson's is just a compilation of cases and said it's the majority. It's not espousing one view or the other. It's just a horn book, I guess, or a thesis that says this is what the majority is.
Right. And
It
this,
doesn't tell you why it's a better rule or not the better rule.
and this court has found it to be instructive. So I guess that would be our position. For example, in Kaler, this court has relied.
I mean, actually, in this case, he does seem to advocate for your rule, but I think Justice Wiggins is right. Normally, it's just a compilation.
Correct.
But I mean, following up on his question, I mean, this employee had a history of seizures. I think that was known to to Long John Silver's. I mean, maybe he should have been wearing some kind of headgear. He had fallen before. But the point of comp is that even if the employer uses all the utmost safety measures, if it's an injury associated with employment, then that's kind of a cost of doing business, isn't it?
It is. But it has to be a risk associated with it. The medical causation, and again, the medical causation isn't the issue. The issue is if somebody has a seizure, if they have an idiopathic incident, idiopathic fall, and they go straight to the floor, unlike Kaler, unlike Lakeside, unlike any of the other cases that have come before this court, is what hits you, is once you strike the floor, is what's there, is that the risk associated with the employment? Or
Is another way to look at it is he's facing the same risks of daily living, whether he's on the job at Long John Silver's or walking down a concrete sidewalk or walking anywhere that there's not a padded carpeting.
And that's what in the McElravy, it turned out later on that there were some aggravating factors. But if you look at the court in McElravy, it's a bad faith penalty case. But they looked at the earlier denial, and in McElravy, they found that to be reasonable because the first kind of round of investigation determined that there wasn't anything that contributed to the fall. It was that it was just it was level ground, and then there wasn't anything else there. Again, my time is almost up, but I was an actual risk state. If you look at the language in Medema and you look at the language really Medema is the most instructive, there has to be some risk associated with the employment, and it's not an issue of once you strike the ground. That's a medical causation issue, but the issue is arising out of. And it looks like my time is done. The only other thing I would say is I agree that if the court were to determine differently as to the compensability issue, I would request a remand to the district court for remand with further instructions to the commissioner. Thank you for your time.
Ms. Dickson, thank you as well. Mr. Novotny.
Thank you. Just going back to some of the case law in Iowa, in Benko Manufacturing versus Albertson, the court concluded that an employee who fell backwards into a cement wall screening in a restroom sustained injuries arising out of her employment. The court held that the cement wall screening the restroom door is related to the working environment and aggravated Albertson's injury from her fall by breaking her neck. And so we see it as being the same type of issue here. Instead of hitting a hard floor, she hit a hard wall. So we see no difference between a floor and a wall, and we believe that he should be compensated for that. With regards to an argument that a wall is different than a floor, if you are inside a building, you're going to be subjected to a wall, similar to your background there. You have a tile wall. Someone fell, hit their head against that wall. They may have had severe injuries, as well as Mr. Bluml when he hit this floor.
This case involves a seizure, and the problem is he didn't brace himself at all because of the nature of the fall. He just fell directly backwards, and all the force went directly on his head. Now, if there had been a carpeted floor and his injuries, let's say, would have been less severe, but he still would have suffered injuries, couldn't you be here arguing the same thing?
Well, certainly if the hardness of the floor, I mean, if you had the same type of injuries, I guess the same argument could be made that even though it was carpeted, that it was so hard that it caused him severe injuries. If it'd all be based upon the facts of the case and whether or not a judge or a medical provider could assert that caused his injury. Hitting the floor, whether it's carpeted or a hard tile floor, whether or not that caused his injuries.
Mr. Novotny, I think we can all agree that the general rule is that there has to be some risk associated with the employment. To adopt your position, would we have to do away with this idea that it has to be a risk greater than what would be encountered by the general public?
And I believe that's already been established in Iowa.
Explain that to me then.
Well, in the Whitaker case, and I believe it's, and I'm sorry I don't have the specific case, but I think it says that Iowa has abandoned any requirement that the employment subject the employee to a risk or hazard that is greater than that faced by the general public. And that was in the Whitaker case. I believe they were citing another case, and I'm sorry I don't have that right in front of me, but I believe that Iowa has already abandoned that requirement.
All right, in Lakeside, the casino case.
Yeah, thank you.
But we also, there were other factors in that case, there was more than just the floor itself. I guess that's where I'm targeting my question of, in these instances where there's just a level surface.
Well, in Iowa, this is a case of first impression. We've never had this type of case in Iowa before. But the way I look at it is if a person can fall into a wall, it's the same as falling into a floor. If they have sustained severe injuries, that work condition has caused their injuries to become more severe. It's a condition of the employment. In this case, he had a hard tile floor because he worked at a fast food restaurant. He's subject to that condition.
Counsel, hard floors are ubiquitous. They're all over. They're right out in our atrium. To follow up on the chief's question, aren't we watering down, if not eliminating, the arising out of the employment element required for compensation if we say anytime you fall on a hard floor, it's a comp claim?
Well, I believe that the courts, like in Benko, they look at the situation where the person fell into the wall. It's the same type of situation.
Benko wasn't our court, right? That was Court of Appeals.
Yes, Your Honor. So I mean, when you look at that, I guess there is a slippery slope if you want to take that view. However, I believe that the courts have. I think the courts should view in favor of the employee in these instances. So, thank you, Your Honor.
Mr. Novotny, thank you as well. Ms. Dickson, thank you again. The case is therefore submitted, and the bailiff may adjourn.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.